Swayam Prabha. Digital India. Educated India.
Start. Still 2 minutes are there. Yes. Can we start? Still 2 minutes are there.
Yes, sir, start, sir. No problem, sir.
Okay. So, hello everyone. Welcome to the live session of our NPTEL course on medical law. So, this is the second live session we are conducting. So, after the previous live session, we had completed 4 weeks of course. So, in these 4 weeks, we have discussed about healthcare and intellectual property rights, in which we extensively discussed about the role of intellectual property rights in promoting medical innovation and technology. We also discussed about the role of intellectual property rights in health policy formulation. In week 6, we discussed about medical jurisprudence and forensic science, where we discussed about the interface of medical jurisprudence with evidence law. We discussed about the duties of doctor, the admissibility of forensic evidence, various legal procedures in medical practice, and the procedures for collection, preservation, and dispatch of forensic evidence. In the last 2 weeks, we have discussed about surrogacy and assisted reproductive technique. We extensively covered the legal regulations with regard to surrogacy and ART techniques. In the last week, we covered the regulatory law on clinical trials and organ transplantation, in which we discussed about the legal regulations which are applicable for organ transplantation and clinical trials. So by this time, you might have understood that this course is actually focusing on the interface between medical profession and legal profession. So the faculties of this course are also from 2 different fields. Professor Chaitanya Mittal is a medical professional, and my expertise is in legal field. So we have created a blend of these 2 expertises for developing this course on medical law. So I hope you are enjoying the course, and now it is coming towards the end of the course. So now I request Professor Mittal to say a few words.
Hello everyone. Good evening, one and all who are attending our course and now the live session second. So maybe the few learners have not attended our live session first. Those who are new for live session, I'll just let you know that in the previous session, we discussed about the first 4 weeks, what we have taught in our course, which was about the consent, medical negligence, and other topics. And in the last 4 weeks, for which this live session second is there, we discussed these topics are the intellectual property rights, medical jurisprudence and forensic science, organ transplantation, and other various aspects of medical legal aspect of the organ transplantation or the surrogacy. So those who have any questions right now, they can put in our chat box, and the questions asked by the learners in the discussion forum, we will be discussing today. But the those who have not attended the live session first, they can go through our recorded YouTube video. And today we'll be discussing the new questions which are asked on the discussion forum related to the last 4 weeks, that is the 5th to 8th week of our course medical law. So now we will starting for the discussion forum questions. Meanwhile, if you have any new questions, you can put it in our chat box. We'll like to answer. And if you have further any queries, you can put it in our discussion forum and mail us. We'll respond accordingly. So we'll start with the discussion forum. The questions asked for the 5th week, any regarding the intellectual property rights. If you have any questions, you can ask to the Professor Narendran. And among the discussion forum, nobody has asked any particular question related to the intellectual property right. But still, if you have, Professor Narendran will answer to you.
Okay. One question that has come now is regarding the exam format and how many questions has to be answered within 180 minutes. So regarding the logistics part of the exam, you will get an intimation from the NPTEL office. Once the hall ticket is issued to you, you will get to know what are the procedures to be followed. But regarding the exam, there will be 50 questions which has to be answered in 180 minutes. And this will be a computer-based test. So all questions will be MCQ questions.
Any other questions you want to like? If any technical issues are there regarding the exam center or any further issue related to the exam, you can mail it to our technical team also, and they will better respond and they will help you out more appropriately. And we will also forward your queries to them. So now we'll be starting for our academic queries, whatever you have. So we can start with the discussion forum. So it was asked, like, if a girl is minor, that is less than 18 years. Particular question was on teenage girl, but we can consider as a minor that does not attain the maturity. That is a less than 18 year. She is unmarried but found to be pregnant, and it has been diagnosed by the radiologist during the ultrasonography. Whether the question being asked by the learner is whether the doctor, or can be anyone, radiologist or gynecologist, is responsible to inform the police or the consultant whom the patient has the responsibility. So it is always that first treating doctor or the first doctor to whom the patient has come up. Either it's a gynecologist or it is a radiologist. And if doesn't obey the POCSO Act, that POCSO Act means the Protection of Children from Sexual Offences 2012. So according to this act, if any minor girl is found to be pregnant, less than 18 years of age, it is an illegal or it's not allowed, even with their consent also. So it is bound duty of an first treating doctor, who can be any gynecologist, radiologist, to inform to police immediately following the POCSO Act 2012 and doing the further examination. Over the phone, he or she, the treating doctor, can tell that such case has come up. Should not reveal any identity at a while. Later on, you can call the police, FIR can be put, then examination can be proceed as per the inquest report received from the police, and you can follow it as per the POCSO Act guidelines. So this is the scenario. So it's overall, it is mandatory duty of the doctor to inform to the police and higher legal authorities whenever there is an not following the POCSO Act 2012.
Okay, so now let us see the second question which has come in the discussion forum. If a person working in a government office consumes alcohol and brought to a doctor for drunkenness, certificate by head of institution of that office, whether doctor can give the certificate or not. So there is no specific law which deals with the procedure that has to be followed, but however it depends upon the professional judgment of the doctor. So, but there is an obligation on the doctor to take the consent of the person before he is examined, even though he is in a drunken state. So it is better to take the consent of the person before the examination is done and a certificate is issued. And if the request is coming from head of institution of a government office, then of course the written request can be taken from the person. And one more thing, the head of the institution means that he may be the employer of the person who is brought to the hospital, but however he doesn't have any authority to take any person into custody. So no person can be involuntarily subjected to any kind of examination. So that issue also has to be taken care. So the examination has to be done only with the consent of the person.
So I just want to like to add in this. So if learners can feel that how we can take a consent from an intoxicated person, but you should always understand that now right now this person is a patient for you, okay, for a treating doctor, for the clinician, anyone, okay, then you have to proceed the examination. If so, how the opinion comes, the person has not consumed the alcohol, So if you have done the examination without consent, then you will be held liable. So definitely always before examining, consent is mandatory. But if it has come up that the person is intoxicated, still it's okay, because you have examined as the request has come from the head of the institution or the person have been brought by the police. So it is always mandatory to take the consent, and then as per the opinion. If the opinion can be the person has not consumed the alcohol, second opinion can be person has consumed the alcohol but intoxicated, and the third opinion can be the person is intoxicated, is not able to perform his regular activities like even uh, driving or anything, even not able to walk properly. So intoxicated state. For that purpose only, the like at the government office, you can't work in a drunken state. So that is the scenario. Maybe the learner has asked. I think it's clear. If still you have a doubt, you can put it in a chat box.
And now we are discussing those questions which have come in the discussion forum. But you have any additional doubts, that also can be put now in the YouTube or in the comment box. So that also will be answering now. Another question that has come is, who gives consent in case of MLC if the child is under 12 years of age? So, and if there is no legal guardian present at the hospital. So in case of a child under 12 years of age, if it is a medical legal case, and if there is no legal guardian who is present, the consent may be given by a person who is having legal custody of the child, or maybe if the person in charge of the institution where the child is receiving the treatment can also take a decision. This is given in Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations of 2002. Another doubt that has come is regarding the one of the cases with regard to trademark, which is Cadila Healthcare and Cadila Pharmaceuticals, whether they are the same company. One question has come. No, they are different, two different legal entities. So that is why the dispute has come. I'm just clarifying that.
Yeah. So now next question being asked on the doubt or the clarification on the theory borrowed servant doctrine. So you should understand the term means a borrowed servant doctrine. The name itself said servant has been borrowed. Okay. So I think the doubt come with the vicarious liability. So first you have to understand what do you mean by the vicarious liability. It's a master and the slave relationship or the employer-employer relationship. So when the person who is working in an institution, either the hospital, tertiary care hospital, or anywhere in any institution, the employer will be held responsible for each and every action of that employee while working on duty inside that hospital, and there should not be even a gross negligence. For definitely for the actions, whatever being done, employer will be held responsible, but also the employee also. If he does so any criminally negligent, then definitely the employee will be held completely responsible. But now the case of borrowed servant doctrine. That means that the employer has borrowed from somewhere else, from the second employer. Here comes the third, means the second hospital. From that one person, one new doctor has come up to the first hospital. So that the particular person who has the come up in the first hospital, his employer will not be responsible for his or her actions done in the first hospital. So the second hospital employer, from where the first employer has borrowed the servant, that employer will not be responsible for the actions done by that person, okay, inside the first hospital. So this is the borrowed servant doctrine. So who will be responsible? The employer who has borrowed that servant, and whatever the action he does so, that the third doctor does so in the first hospital, so the first hospital employer will be held responsible for the actions done by the borrowed servant. So this is the theory of borrowed servant doctrine. Hopefully it's clear, right? So now another question being asked on the screening of the various tests before going through the any operation or any procedures, like whether there is a mandatory testing of screening the blood donors, sperm donors, organ donors for any viral markers before proceeding. So it is always nowadays it's a happening routinely, and people are also not asking. But actually, it's necessary to have a concern and a proper counseling to be given to the donors, like who have come up for the blood donors. So we are, without telling them, we are running their blood to the viral markers. And if it comes to the positive, then so it is always better to take in concern, saying that this blood can be go through the various tests, that is a mandatory testing, or the organ donors, that it is necessary. It's a protocol of organ transplantation or the blood donation. So it is to be must to be informed. And then if it comes anything positive in case of any viral markers or any corrections in the or any disease or incidental findings, it is necessary to inform to that particular donor in a counseling way. Should not tell randomly or in a haphazard way or in a public. So you should call him, counsel him properly first, and then disclose the information. So that is the thing. So always during mandatory testing, it's necessary to have an concern, proper informed concern, and then you proceed for a viral markers. Even for a small surgical procedure, surgeon should be aware of. Better to take an informed concern properly and then proceed.
Okay. So now let us see some questions which has come in the YouTube. So one question that is asked is, one of the questions in the assignment 7 was about the year of enactment of PCP-NDT Act. The answer given was 1994, but it was PNDT Act that was enacted in 1994. So the letters PC was added to the amendment. So how can we say that PCP-NDT Act was enacted in 1994? Even the slide says PNDT Act was enacted in 1994. So 2002 should be the correct answer. That is what is pointed out by one of the listeners. But let me clarify that once the amendment is made, it doesn't change the year in which the act is enacted. Okay. So amendment means that the act is already existing, but some changes has been incorporated into the legislation. So you can also refer to the section 1 in the legislation, where the short title and extent of the legislation is given. So there also it is clearly mentioned that even though I understood that it is your point is that it was added only in 2002, but still it was enacted in the original legislation was existing from 1994 onwards. The amendment has happened in 2002. So when the amendment happened, even the name of the legislation has been changed. But in legal language, when you give the name of the legislation, it will be the new name because it is amended, and it will be considered as enacted from 1994 onwards. What has happened is only an amendment. So the correct answer will be 1994 itself. But you are correct in saying that the amendment happened in 2002.
Yes.
One more question that is come is, if a doctor keeps a patient on ventilator, make money, can we file a criminal case? So this has been extensively discussed in week 3, where we discussed about medical negligence and malpractice. So if whatever is happening is coming within medical negligence or malpractice, then it will be dealt accordingly. But otherwise, if it is a correct decision of the doctor, then there won't be any legal consequences. So let us go back to some questions that has come in the discussion forum. Can I start?
Yeah.
So one question is, why is commercial surrogacy banned in India? So commercial surrogacy is banned because women are being exploited. You know the Indian situations where there is economically people with economically disadvantaged backgrounds who are coerced and forced into surrogacy for monetary gain. So that is why commercial surrogacy is completely banned in India. It is considered as an unethical and illegal practice in India. So through the legislation, the government has already prohibited commercial surrogacy. So the law only promotes or provides for altruistic surrogacy, which is intended to protect the interest of the surrogate mothers and the children who are born out of surrogate relationship.
So the another question being asked that, can a woman can act as a surrogate mother, but like how many times? Or it's being asked that can be allowed more than once in her lifetime. But no, it's as per the clear by the Surrogacy Act, it's clearly mentioned that as per the Surrogacy Act, the surrogate mother who is already having the 2 children more than 35 years of age, it's being allowed only once in her lifetime as per the rules and the guidelines mentioned in the Surrogacy Act. If she is eligible to become a surrogate, then only even she is allowed once in her lifetime, not more than that. You have any other queries, please put in a chat box on live session on YouTube.
Some questions that has come in. So let us go back to these questions. Why are activists protesting against the Assisted Reproductive Technology (ART) Act? So this is another question that has come in the discussion forum. So this is actually because it provides for surrogacy only with regard to people who are married and in a heterosexual relationship. So civil rights activists or others are asking for extending it to other persons as well. That is why there is some criticism against the Assisted Reproductive Technology Act. Another question that has come is, what is the objective of ART Act? The primary objective is regulation and supervision of assisted reproductive technology clinics and the banks, and also to prevent the misuse and also to ensure the safe and ethical practice of assisted reproductive technology services.
So now another question being asked on the PCPNDT Act. So you have to first understand what do you mean by it. It's a pre-conceptual, prenatal as well as a postnatal diagnostic test. So it is the main thing why it has come up, especially for the radiologists or the clinics. Okay, it should be properly registered. Secondly, the radiologist should not do the scan for sex selection. Only it is being allowed for the diagnosis, any genital disorders, any chromosomal disorders, any finding out the any prenatal anomalies, or the accordingly the if there is a need of abortion, that can be done. Should not be misused, that is specifically for a female feticide or infanticide. Okay, so that is the main aspects of the PCPNDT Act. Any other questions you have?
Question that has come. Is brain death different from vegetative state?
Yeah. So now the question being asked on related, this will help in the organ transplantation. The question is being asked that whether the brain death and what is the difference between the vegetative state and the brain death. So you should know it with the few examples I have given of movies during lectures also. Okay, if you remember it. But I just say that it is completely brain death and brainstem death, you can say so. Or you can say complete death and coma condition. Okay. So vegetative state is a PVS, persistent vegetative state. Okay, the person is in coma or the brainstem death. The circulation and the breathing is not done. So that is maintained by the artificial heart and lung machine from outside, and the brain is working. So with the help of artificial heart and lung machine, that is a ventilator, you can say so. So the person is being in the coma condition. Brainstem death is there, but brain is working. So able to understand, but not able to do any actions. Okay, just heart and breathing is to maintain the person life. So whenever the person can come up from the persistent vegetative state, there are many scenarios are there that person has come up even after 10 years or 15 years or 20 years. Okay, but this has come up with an famous case of the nurse who or she was got a gang rape, sodomized, and was under pre-vegetative state, and she couldn't come out and died. For that only the passive euthanasia has come up, and now it is being legally allowed as passive euthanasia. So these two terms you should able to understand, the vegetative state and the brain death. Brain death is the whole death. The brain death is there, so you can proceed for then any organ donation case. So if a person has filled the form or the relatives want to do any organ donation, you can proceed it. But in vegetative state, you can't proceed for the organ donation. You have to wait till the brain death occurs, or maybe it's a miracle has come up. So the vegetative state person is not allowed for any organ donation. Brain death are being allowed for any organ donation. So I think it's a clear, it's a completely different. Brain death, brainstem death. Brain death, it's a whole like death, and the vegetative state is only the heart and the lungs which are working as per the artificial lung machine. So brainstem death is the persistent vegetative state. So another being question was asked on. Yes, sure.
So one question that has come is, what is the maximum duration for which cryptozoid embryos can be stored as per the ART Act? So it is pointed out that there is 5 years mentioned in the lecture, but in the assignment it is 10 years. So the correct answer is 10 years, because it is, you can refer to section 28 of the Act, where it is mentioned that the maximum period for which the embryo or the gamete can be stored is 10 years. You can refer to section 28 of the legislation. Another question that has come is how the cases are filed on medical cases like original suit or writ petition. So if it is medical negligence, then it will come as a criminal case. So it has to be filed in a criminal court of competent jurisdiction. So depending upon the offense, whether it is before a magistrate or a sessions court. And so that is about this medical cases. Another question is, do we have advocates for medical law in the country? So there are a lot of professionals. So normal legal practitioners would be able to handle medical legal cases as well. So they will, those who are having expertise, you can approach them. Another question that has come is, if a girl under 18 years coming for ultrasound found to be pregnant, whether we have to inform the police. So this is after the POCSO Act. It is mandatory that once you come to know that an offense under the Act has been committed, you are duty bound to inform the police. And if you do not inform the police, then you will have to face legal consequences. So there is also punishment prescribed for this under the POCSO Act. So if the child is a minor and you are found that she is pregnant, then it is constituting an offense under the POCSO Act. So it is better to inform the police. If a person working in an office brought to government hospital by office authority for drunkenness certificate, shall a doctor give certificate or inform the police? You want to answer?
Yes. So if person is working in office and brought to the government also by the office authority for drunkenness certificate. So in that case, so the person who is working now, it is either now presently working or even it maybe from home, whatever the being the scenario. So the person has come up to the treating doctor for an examination by the higher officials or that particular office authority or anyone. So it is a duty bound by the doctor that this case is medical legal case. Right now the person is drunken, okay, in drunken condition. Okay, so it is necessary to inform to the police that such medical legal case has come up. Secondly, he can proceed for an examination after taking the consent from the person that kindly give a consent that we are going to examination for your finding out the drunkenness condition. So if it has been found as an consumed alcohol or not consumed alcohol, or secondly consumed alcohol, then whether intoxicated or not toxicated, with the help of the various reflexes to be done by the person who is in drunken condition with the help of treating doctor. So this is a scenario. So the point is both the things. The doctor has to inform to the police that such case has come up for an examination. Second, has to examine also without waiting for the police to come up. But both the things has to be done.
Okay, so another comment is regarding one of the mistakes in slide lecture number 32, where there is a mistake in mentioning the age of females and males who are entitled to be in a surrogate relationship, in a couple for surrogacy. So thank you for bringing this to our notice. We will check the slide, and if there is any mistake, we will rectify it. Thank you for bringing this to our notice.
Any other questions you have, then please let us know. Even you can ask from the previous weeks also, from week 1, week 2, week 3, week 4 also. Any questions related to our course, medical law? And in the last session, many have asked that whether we can start practicing or not. Now, you should be aware that in the NMC Act has clearly come up in the section 34, there is a punishment for quackery. So you should be proper, having a degree of MBBS degree, and then should be registered properly. Similar way, you should have proper degree of LLB, properly registered, then only you can law practice. So this medical law, it is for your helping out to deal with the various cases come up in your ongoing life. Okay, if you are even clinician, so this course will help as in dealing with the various medical legal cases come up. Okay, that doesn't mean that you can start practicing. Okay, so there is a punishment for doing a quackery. Okay, that is under section 34 of NMC Act.
Sorry, just to give one more clarification, this is actually both are regulated professions. So both the medical profession and legal profession are highly regulated professions. So both are being regulated under two different legislations as well. So practicing medicine without proper degree or proper registration is a punishable offense. It will be considered as a very serious crime. Similarly, practicing in legal profession also requires proper LLB degree and also enrollment with the bar council. So this is mandatory in India.
So the question has asked that whether a doctor to get consent for transvaginal ultrasound. So see, you have to understand that whenever any case, it is not that necessary of an pregnant case or even gynecological case, it is an abdominal ultrasound or transvaginal ultrasound, there is a completely F form is there associated with Aadhaar card. Okay, so any ultrasound, whenever the machine get an entry, form F is being filled with an Aadhaar card, there is an entry inside that ultrasound machine, and then only the radiologist, the sonographist, who is legally authorized to do, then only can proceed. Whether that is a transvaginal ultrasound, transabdominal ultrasound, for a pregnancy, for any gynecological condition, for anything, even for the whole abdomen ultrasound. So it is always necessary to take in consent in the form of, that is a form F. Okay, so then only the ultrasound machine can be on, you can feel in that way. So that mandatory, it has include everything, what is a procedure, and the consent is also being mentioned completely, that F form is filled and attached with an Aadhaar card link. Then only the radiologist or sonographist can perform the ultrasound. And another scenario, we can tell that new changes have come up, that the Indian Penal Code, IPC, CRP Criminal Procedure Code, and Indian Evidence Act, the new name have come up. Few changes have been also done, which will be come into the force from the 1st July onwards. So we will also do the few amendments in our course. Meanwhile, till for the this year June, it's being the IPC, CRPC, and Indian Evidence Act. Okay, so in the further, whenever the rerun course can up, we will do the few amendments in their names and few changes in the act. Meanwhile, you can also go through, those who are learners already have gone through this. So we are just telling right now, there are the few changes just with the name. Okay, so the name has been changed, IPC, CRPC, and Indian Evidence Act. Okay, so not major changes, only the few changes. So anything, if you have any queries related to anything, Organ Transplantation Act, Surrogacy Act, any scenarios of medical negligence, or the clarification on medical jurisprudence and the forensic science, or how to maintain a chain of custody. So overall, it is very much necessary for the clinician is that in whatever being the scenario, the documentation is very important. The lawyer or the judges or the law side, whatever they say is that if it is not documented, the doctor has not performed that act. Simple thing is that. If you have documented even the date and time, even you can't do overwriting. Okay, so recently the case has come up of a neurosurgeon. Okay, so the person has come up on 22nd, it has overwritten as 18. So you should never write any overwrite. Okay, even by mistake, you are not remembering the date, today's date. If by mistake you have written any wrong date on that particular date, maybe you are correct. So it's completely single strike over that and write a new. Don't do overwrite. Overwrite is not allowed legally. Okay, and whatever you are doing, so please document it properly in a clear, legible handwriting, which is readable. That is the thing. Readable is necessary. We are not telling that you should write in a beautiful way. So readable handwriting, legible, no overwriting, no cutting, so that you should not be held any liable for any scenarios happened in future. So about the crux of the medical negligence is that way only. That is a good defense, documentation. And if any doubt you have that whether this scenario has an foul play or suspicion, you have it's mandatory duty to inform to police. No problem that you have by mistake you have informed. Maybe this case has no foul play, that can be rectified by the legal authorities. But if you feel such, so document it and inform to police that according to me there is some issues, maybe the child abuse or sexual abuse or any case which has come up during routine OPD or emergency scenario. You feel that there is a foul play, suspicion, medical legal case, legal authorities to be taken any action, please inform to the police. If you are not doing so, then you are negligent. You are held responsible. You can be punished. Okay, for hiding the evidences, for not informing to the police. So better to inform to the police each and every doubtful, suspicious case, even if you don't know that whether this is documented as medical legal case or not. So if you doubt, inform to police and then label it as medical legal case that you have informed to police, and then let the police take the call. Police will proceed if they feel, then further proceedings can be done by the doctor and the police together.
Okay. Another question that has come is with regard to inconsistency between Rule 25 of the ART regulation rules and also Section 28 of the Act. So Section 28 specifically says that gamete of a donor or embryo shall be stored for a period of not more than 10 years. And at the end of such period, it shall be allowed to perish or be donated to research organization. So this is a mandatory provision under Section 28 Clause 2. But when we come to 25, Rule 25, it is with regard to oocytes and sperms. So with regard to embryo, the mandatory period is 10 years as given in 28 Clause 2. But with regard to oocytes and sperms, then of course there is a provision under the rules which facilitate its preservation even after a longer period than 10 years. So another question that has come is why diagnostic procedures are not eligible for patents. So this is actually, so there are certain direct exclusions under the Patent Act. You can refer to Section 3. So many of these things are actually considered as innovations which are required for general public. So what happens is, if intellectual property rights is granted, this is going to significantly increase the cost of diagnostic procedures. So in order to ensure that it is available for everyone, during the negotiation of international treaties itself, it was agreed that certain things will be kept as unregulated or unpatentable, so that it will not be considered as innovations which could be propertized by individuals. So that is why you can see this is also considered as unethical also. Because what happens is, diagnostic procedures, if it is patented and if it is available only to people who are having the capacity to pay, then it will affect the general population's access to medical technologies. So that is why we have certain specific exemptions under the Patent Act, which speaks about innovations which cannot be patented. Another question that has come is, what is the scope of job opportunities for advocates in the field other than dealing with medical malpractice cases? So now in our course we have covered around more than 6 to 7 legislations we have covered. So all these legislations are regulating various aspects of medical profession. So medical negligence or medical malpractice is only one side of it, but there are regulatory laws which handle the functioning of clinical establishments, that is in medical industry itself. So legal practitioners would be required to give proper advice to clinical establishments on how they shall function. Similarly, in surrogacy and assisted reproductive techniques, and also in case of clinical trials also, we have seen there are a lot of legal regulations. So only a legal professional or a qualified legal practitioner would be able to advise industry or sector-specific business operators about the legal regulations that they have to comply when they are operating in this field. So there is a huge demand for medical practitioners who has expertise in medical law.
Another question being asked, that whether the government hospitals are included under the Consumer Protection Act or not. You should understand that what do you mean by the consumer? Okay, so whatever being the facility given by the government hospital or the private hospital, if it is a chargeable, that means that the patient has become consumer. Okay, so in the government hospital also, even if they charge 2 rupees for the OPD ticket, okay, for an example, it's a very minimal in the one, but still it's a chargeable. Second, the investigations done or the bedding charges if admission. So if it is chargeable, then it has become the consumer. So the government hospital also comes under the Consumer Protection Act. They will not be able to do any gross negligent. Okay, but whatever the negligent happens, okay, so that has to be proven. Like for an example, if it's an administration side, if any infrastructure is not available, or if any instrument failure, so that will be through the corporate negligence. It's not only the criminal. So criminal negligence will be when there is any death occur or when any gross negligence done by the doctor, even that is a government doctor, and that is the thing is the res ipsa loquitur follows. That is the things which speak for itself. So overall, the government hospital definitely comes under the Consumer Protection Act. So another question being asked, that the learner is running a scan center, as it's necessary to inform to the police directly, or it's the patient is being referred from another doctor. So it's always good that the doctor has referred to you. So maybe you are doubtful whether that the referred doctor may inform or not. It is your legal duty to, you have come up, okay, that the teenage girl or the minor girl is pregnant. So you are the radiologist, you are the sonographers. So you should inform to the police, and definitely also inform to the referred doctor that this is a scenario I have found out, and document it properly and attach it and send that file back to the referred doctor. So it's always mandatory to inform to the police from your side as you have found it out. Okay, it's not that your duty to inform back to the doctor, then it is his duty, because you have diagnosed that the patient is pregnant, and you have, it's legal duty to yourself that you should inform to the police.
Another question that has come is regarding the exam. Are we expected to know the cases mentioned in the lectures for the exam? Previously also there was another question regarding the patent. So I'm just again clarifying that for the exam it will be a computer based test, and you will be asked only 50 questions, and those are MCQ questions. So there won't be any descriptive answers required from your side. So the questions will be MCQ. So you just have to opt among the different options given in with regard to each question. So you have to have some basic awareness about the issues that have been discussed in the 8-week course. And you may be already familiar with this from the assignments, because assignments also we have followed a MCQ method. So similar method would be followed for the exams also.
So again, clarification being asked that whether the government hospital are included under CPA or not, as the services done free of charge. That I told. Whatever the services are provided by the government hospital, which are free of charge, then that is not in comes under Consumer Protection Act. It's clearly said. You have to first become consumer. The patient has to become first consumer. Whatever the services taken by the government hospital free, then means that the patient has not become the consumer for that hospital. But if the charges are being asked even 2 rupees, even 10, whatever, then the patient has become consumer. That doesn't mean that the government hospital has become a got a license to kill or to do any negligent. Okay, so has to perform properly in a rules and regulations way. So definitely, if any charge is being asked, if the patient has become consumer, then the particular government hospital or particular patient has become consumer, and the doctor or the institute comes under Consumer Protection Act.
Again, it is asked as to how many questions. It is 50 questions over 3 hours. Yes. I think we have discussed almost all the questions that has come in the discussion forum as well as in the YouTube. So if you have any further questions, you can ask now. And we hope that you are enjoying the course. Okay. So thank you everyone for attending the live session. In this 8-week course, we have tried to comprehensively cover various aspects of medical law, focusing on the interface between medical profession and legal profession. So we have dealt different legislations that are applicable to the medical industry. So I hope this course was useful for you, and wish you the very best for the exams.
Thank you, learners, those who have registered for our course and as well as exam. And thank you very much those who have given the feedbacks, and either the positive or the negative or any of the changes. Definitely will do the rerun. I will also suggest that those who have missed anything, they can do the rerun, apply for rerun, and can gain further knowledge in that. Definitely few things will be added by our both the faculties, as well as the few like as per the feedbacks given by the learners, few changes will be there in the rerun course. So anything else you want to ask right now, you can ask us, or even you can put in the discussion forum. And best wishes for your exam.
Yes. Again, actually, one question has come: will the exam consist of only MCQ or essay type? So again, it is clarified that there will be only MCQ type questions.
Yes.
Okay, and as Professor Mittal was saying, when we have the rerun of the course, please listen to the course again, because there will be a lot of changes, because the Criminal Laws and the Evidence Act also has changed. So we will be making some changes in the slides as well. So even if you are not writing the exam, because now you are about to write the exam, so you can write the exam this time, and then again you can attend the course without making any payment, because when it is given for rerun.
That will be very useful also for the like a revision and the new amendments as the law and the medical like whatever the acts and the laws comes up, there will be definitely changes or the amendments. So that will be update in our course also. Okay, so it will be very useful. Thank you.
Thank you very much.
So you ended or live streaming?